Check, check, check. Good morning, everyone. Welcome to the Banking Committee's first public hearing. I want to turn it over to my co-chair to see if he has any words. And after that, my ranking chair, Representative Delnicki.
Thank you, Madam Chair. No words can describe how excited I am to start our first public hearing. So let's get to it. Thank you.
Thank you, Representative Delnicki.
Thank you, Madam Chair. And today is when we finally start the public part of our work. And I'm truly looking forward to hearing from the people. Thank you, chairs.
Thank you. Oh, I'm sorry. And my Senator ranking chair, Senator Berthel. Good morning, sir.
Good morning, Madam Chair, and I would align all of my comments with those that have already been shared. It's always good to have public hearings and listen to the people. So let's get to work. Thank you.
Thank you. So our first speaker today is Matt Smith from the Department of Banking.
Good morning, co-chairs Miller and Doucette, ranking members Delnicki and Berthel, and honorable members of the Banking Committee. My name is Matt Smith. I'm the Director for Government Relations and Consumer Affairs at the Department of Banking. And I'm here today to testify on several agency proposals that the committee has raised and has offered for a public hearing. There are several proposals. I will speak on each of them in no particular order, but I will tell you which ones I am doing. The first one, HB 6875, an act concerning the Connecticut Uniform Securities Act. This proposal does three things. It creates a state broker-dealer registration exemption for merger and acquisition broker-dealers who facilitate changes in company ownership and leadership for these securities companies. The merger and acquisition brokers work with sophisticated investors who are well-informed and understand the risks involved with these types of business transactions. Average investors are not involved in these transactions. This is a conforming change to a federal exemption that already exists. The second part of the proposal, the department receives between 20 to 60 notice filings each year for Tier 2 securities offerings. Currently, the Securities and Exchange Commission preempts states from requiring Tier 1 registration fees, but does allow for notice filing fees on Tier 2 securities offerings. The majority of states have enacted notice filing fees. This proposal creates a notice filing fee of $250 for these Tier 2 securities offerings in Connecticut, which is in line with the majority of the states. I think there's about 27 different states that have a Tier 2 notice filing fee, and the fee is about the same for each of those states. Finally, for particularly egregious violations, the banking commissioner has the authority to ban individuals from working in banks, credit unions, and those non-depository financial service entities regulated by our Consumer Credit Division. The Securities and Exchange Commission also has this same authority. This proposal authorizes the banking commissioner to censure or bar a registered broker-dealer, agent, investment advisor, or an investor advisement agent based upon the grounds enumerated in Section 36B-15A, subject to the registrant's right to request a hearing. This would bring parity with our enforcement powers across each of the divisions in our department. It provides flexibility when enforcing security laws for the state. And those are the three things that bill does. I can stop and take questions, or I can continue with the other bills, however you would like to proceed.
I'll prefer to see if members have questions at this point, Matt. Thank you. Are there questions from the members? No, then you can proceed. Thank you.
Thank you, Madam Chair. The next bill is an act concerning consumer credit and commercial financing. This is Senate Bill 1257. It is a bit of a long bill. It has many sections. This is a resubmission from last year. And I'll go through each of the sections and the different proposals in each section that the agency is requesting of the committee. Sections 1 through 5. Licensees required to maintain a surety bond as a condition of licensure are also required to maintain their license on the National Multi-State Licensing System. This is a system that is used the vast majority of states. I think it's like 45 or 46 states use this same system. And what it does is it allows us to monitor licensing. It allows consumers to check out different companies and see if there are any actions against them, to see if they are actually licensed to do business in the state. It's a very important system and one that is critical to the operation of our consumer credit division. Recently, the last couple of years, we've required that companies file their surety bonds electronically on the system. What this proposal does is requires them to cancel the bond on the system as well. So this is basically to reduce regulatory burden, increase efficiency, both for the licensee and for the department. Many states have adopted this method, and we're looking to join them. So section 6 through 11, electronic bonds of licensees on the NMLS do not reflect a physical address location. So what this does is it would remove that requirement on the electronic surety bond. Section 12 clarifies that receipt of any payment on retail sales finance installment contracts constitutes activity requiring licensure. Sections 13 and 14 goes back to this electronic bonding thing. Each company that is licensed on the NMLS has the opportunity to have one surety bond attached to their licensee. Well, there are oftentimes we have companies who both originate mortgages and also service mortgages. And those are two different license types. If you're licensed as a mortgage originator, you're exempted from being licensed as a mortgage servicer. But you still need to maintain a bond on the servicing end and the origination end. And so that creates a conundrum on the system when if you're a company, you're only allowed to do one bond. What this does is it creates a mortgage servicing registration exemption. So what would happen is that the mortgage originator would then register as a mortgage servicer, exempt from the actual license, and it would allow them to attach a second bond to their company. So it's a workaround of the system. So it allows us to capture the bond both on the origination end and on the servicing end. And I thought it'd be easier just to sort of go ahead and explain that rather than just reading straight from my testimony. Section 15 will make it easier for cosigners on private student loans to be released from their loan obligation. The proposal places obligations concerning cosigner releases on private education lenders and private education loan creditors rather than on the servicers. Now, this is important because currently, we require servicers to release cosigners. However, because they don't own the loan, they have to be directed by the people who own the loan in order to release the cosigner. So what this does is it shifts the responsibility from the servicer to the people who actually own the loan and can make the decision. So it basically makes it easier for people who have private student loans. Oftentimes they may have a parent or a grandparent that is on the loan with them. A few years ago, it was passed that after a year or so of consecutive good standing payments, the cosigner can be released from the loan, which is an advantage to the borrower there, the cosigner there. But it made it difficult because of this uncertainty about the servicer releasing the cosigner. So this shifts that responsibility from the servicers to the people who actually own the loan. Section 16, currently the commissioner has the right to suspend, revoke, or refuse to renew licenses for entities the department regulates. This proposal extends those authorities to registrants as well. So basically, we have two different types of people that are subject to the supervision of the department: licensees and then registrants. We have more authority over licensees, but we do have some registrants like student loan servicers who service only federal student loans aren't required to be licensed by the department, but they are required to be registered. And what this does is some of the enforcement authority that we currently have over licensees now will extend to those people who are registered with the department. Moving on, Section 17 clarifies that receipt of any payment on small loans constitutes activity requiring licensure. Section 18 repeats that same thing except for mortgage loans. Well, not except for, it captures, Section 18 captures mortgage loans, so that if you're taking any payments on mortgage loans, you need to be required to be licensed. Section 19 makes technical edits to the student loan servicing statutes. Section 20 sets registration renewal timelines to correspond to timelines for the department's licensees. The renewal period opens on November 1st and closes on December 31st. So basically, there are a couple of new registrants that we've picked up. And we're now requiring them to file for renewal at the same time that the window for renewal is open to licensees. Basically, it's a process improvement type of proposal, increases our efficiency at the department, and makes it clear and consistent to the registrant. Section
Matt, can you kind of wrap it up
Oh.
for us, please? Thank you.
Sorry. So the next, the final part of this proposal is doing shared appreciation loans, having specific disclosures to consumers that are specific to that product. And then the last two things, very small. One, we are seeking a clarifying change on the community bank and community credit union investment program established by the treasurer. There was a change made a couple of years ago that looks like it doesn't capture federal credit unions. So what this does is it makes sure that federally chartered credit unions can participate in that program. And then finally, we are modernizing and updating our innovation bank statutes. It's relatively new. Last year we changed the name from an uninsured bank. This year we're modernizing it to conform with the actual practices of an innovation bank. For instance, in this, it removes the effect that, considering the effect that it's going to have on a given population. Innovation banks don't take retail deposits. They're mostly business to business, and they work on the back end of things. So considerations like that no longer apply to an innovation bank. They still apply to regularly chartered Connecticut state bank and credit unions and all of that, but for innovation banks, not so much, along with a couple of other changes that I can expand upon, but I will wrap it up as I've been talking for a while.
Thank you. Are there questions from the members? Representative Delnicki.
Thank you, Madam Chair. The shared appreciation situation there,
Yes.
how is an equivalent APR calculated?
I don't have that information at the but I can get back to you in writing on
Okay.
that.
Because I know that's been a concern on some other products, how
Yes.
the APR is calculated.
Yeah, I
And
don't
when
know.
I saw that, it kind of raised a flag.
I don't know the specific formula on that, but I can get back to you and to the rest of the committee on that.
And likewise, as a follow-up, I know there's been instances where people don't realize exactly what the shared appreciation agreement is, and a number of years goes by and suddenly they sell the property and it's a big surprise. Is there any other ways that the folks are made aware of what they actually have there, the recipients of the money up front?
I'm sorry, what was that again?
Okay,
I'm not sure if I understand the
All right.
question.
in the past, people with a shared appreciation agreement have forgotten about the fact that at the tail end of the loan, when they sell the property, they suddenly actually receive a dunning on what they actually have received for monies. Is there any continuing notification to them just to keep them aware of what's going on and the fact that agreement will come due?
Mhm. I am unsure about that. I know that currently there is nothing in law. And I don't believe that this law has, besides the initial disclosure, has any additional disclosures, but I can confirm that for you and get back to you in writing on that.
Yeah, I'd appreciate that because I have heard of a number of circumstances where people have sold the house.
And then they get hit with
Suddenly
this.
they
like,
realize that instead of a net profit of say $100,000, it's now 40 or 50,
Gotcha.
and they'd totally forgotten about it. So I'd
Understand. I will
appreciate
get back
finding
to
out
you.
if there's any mechanism there that actually makes them aware of the fact that it's out there and that they will have to pay for it at some point in time. But otherwise, smooth sailing on the other items, in my opinion.
Thank you, Representative.
Representative Doucette.
Thank you, Madam Chair. Thank you, Matt. I did want to give you an opportunity to talk a little bit about innovation banks while we're revisiting that. For
Okay.
those who may have not been on here last year on the committee last year, that was an interesting topic and actually brought us back, I believe, for special session. That was something we passed through in special session. So with regard to innovation banks, maybe just a brief explanation of what they are, how many licensees we currently have, examples of what those licensees do, and the department's early experience internally on the regulatory side as far as the innovation bank program goes.
Great, sure. Happy to talk about it. So just as a little refresher, the Innovation Bank was its name was changed from an uninsured charter. The uninsured charter was established in 1999. And for a very long time, there was only one use of the uninsured charter, which it was the United Parcel Service. They used the uninsured charter to offer banking products to their employees. And basically, when we say uninsured, we mean that the deposits do not receive FDIC insurance. But what made this particular charter interesting was that it was backed by the full sort of backing of the multinational, UPS. So they could cover any sort of failure that may have happened, even though nothing like that happened. They wound down the bank. What we now, in 1999, it wasn't really conceived, that we would be moving into this financial technology or this fintech space. And what the Innovation Bank Charter does, it offers a regulatory framework for financial services companies that don't engage in front-end retail deposits. So they mostly work on the back end of the banking system, processing payments. We have, not to get ahead of myself, but the two current licensee chartered banks, we have Banking Circle US down in Stamford, and we have Numisma, which is based in Greenwich. Banking Circle mostly deals with payment processing, and Numisma is a bank that actually moves physical cash around the globe. It is a very niche market that they've been able to capitalize and create a business on. One of the several advantages to the Innovation Bank Charter is that it provides what we call a money services or a money transmission exemption in about 26 other states across the country. So that reduces regulatory burden on these companies, and that's what makes it attractive for them. And if I may boast a little bit. The Connecticut Department of Banking does have a very good reputation as being a strong regulator in the regulatory community across the country. And it is often beneficial for these companies when they're working internationally to be able to cite a strong regulator. It sort of gives the financial services regulatory framework in those countries ease in knowing that there's proper oversight to these companies. We have been working very hard in the department to go, we've already done some work with these banks in examining their applications and examining their processes. And we continue to build on those to increase our subject matter expertise in areas of cybersecurity, in areas of money transmission, money laundering, Bank Secrecy Act, all things that we would normally do for a regular bank, but now applying these to these new fintech innovation banks. Does that capture?
Yeah, how many examiners does the department currently have in that area? What's the staffing?
I'm
look like?
unsure what the staffing level is
Yeah.
on that, but there are dedicated examiners. And in this year's budget, we have asked for 2 additional examiners to fortify that team because in addition to the 2 banks that we do have several more applications that are
Right.
pending before
That's
the
what I-
department.
Yeah, that's what I figured. So starting small and building.
Yes.
That's good. So then my other question is about the change that's in the bill, with respect to, the innovation bank. So that change, just to be clear, in the bill is going to just apply to innovation banks. It's in that section of the statute,
Correct.
correct? So all of that other
Correct.
stuff that's in there about, considering, the, relocation, the population area, the, convenience and needs of the market area, et cetera, that still applies to any other
To-
financial
to is-
institution. It's just
exactly.
the innovation bank, but
Correct.
explain why you think that's appropriate or how that might even come into play with respect to an innovation bank. Because most of those are not they're not gonna have, in most cases, more than one location. anyway,
Exactly. They're
correct?
just going to have headquarters. They're not,
So
they don't
maybe
have
they-
branches or.
And they're all gonna be
Yeah.
located in the state, is that correct?
Correct.
So this would apply maybe for Numisma is relocating from, are they in Greenwich? Is that where they're?
It's in Greenwich, yes.
Yeah,
Mhm.
they're relocating from Greenwich to Stamford or something like that. And that's when this, if they were relocating that's when this statute would come into play.
Yes,
have
exactly.
to-
Or if they were opening another branch or whatever. But again, because they're not servicing the general population, like you can't go to Numisma, walk in and say, hey, I want to open an account. That's just not how they operate. It's a
Right.
completely different business model,
Right. Okay. Okay.
innovative business model.
Makes sense. Thank you, Madam Chair.
Great.
Are there any other questions? Matt, I have a question about the registrants. You said that that they are not privy to the same type of oversight as licensees.
Correct.
Can you explain that a little more for me, please?
Sure. So the easiest example I can think of will be our student loan servicers. We license private student loan servicers, but we register only if a student loan servicer only services federal student loans, then they're only subject to a registration. The reason for that is we were sued, and basically the result of the lawsuit was that we couldn't require contractors of the federal government to hold a license in the state, but we could register them, because a registration, you only have to sort of file with us that you're doing business here in Connecticut, but you still have to comply with consumer protection laws. And with a licensee, we have examination powers, so we can go in and look at their books, look at all of the accounts. We have unfettered access to all of their records if you're a licensee. Not so with a registrant. The only way that we can get in to see a registrant is if we have a complaint filed against them, and then we can use a different part of our statutes, our investigatory powers, in order to go in and take a look at anything that's happening. It's a little bit harder for us to get into and see the records of a registrant. It's not impossible, but that's basically the difference between a licensee and a registrant. It's the examination power is probably the chief difference. Among other things, I'm sure they're not required to hold a surety bond and other things that licensees are expected to do. But we can't go into a registrant and, just appear and say, hey, we want to see your books.
So is what you're asking, is it going to apply to all registrants?
All
or-
registrants in our
all
consumer
registrants?
credit division. So like we also register recently, we do register commercial financing companies. So they would be, so the registrants would be student loan servicers, commercial finance. And I don't know if we have any other registrants. I think maybe a couple of other small things, but I think that captures all of our registrants.
So let us be clear, you want to have the ability to do what with registrants?
Okay, let me just refer back to my testimony so I get it right. Okay, so I'll repeat this. So with a licensee, we have the right to suspend, revoke, or refuse to renew licenses for our licensees. So if they're engaged in egregious behavior or whatever, we can seek that subject to due process for the licensee. So how that would go is we would send a notice out to them alleging certain violations. And then as a result of these, we would suspend, revoke, or fail or not renew a licensee. And then they could request a public hearing and there's a process there. We want to be able to do that the same with the registrants. So if we see that they're engaged in particularly egregious practices, or just violations of law, whether that's, other parts of the Connecticut statute or not, but we want to be able to say, hey, there's still things you have to do, even though you're not a licensee when you're interacting with consumers or your customers or small businesses in the case of other registrants.
So if you revoke, then does that mean that they're not allowed to do business in the
Correct.
state?
Correct.
So if they're going back to your student loan example, you said they're federal contractors, so there
Mhm.
wouldn't be a conflict. You would still have that ability to do that with this?
Yes, to revoke their
Law?
registration, yes.
Okay.
And if they're not registered to do business, then they would have to find another way to service that loan,
Right,
whether
okay.
that's selling it or some other subcontracting out to a different servicer who is registered here, we could see as well. But yeah, but yes,
So.
that would be the idea.
Gotcha. So that means that they can't do business in the state. You say, you make it sound easy that they would have to find someone else to service that loan. Would that be an easy? feat
Relatively
for
easy,
them?
yes.
Okay, all right. Because I understand what you're saying, but what I don't want is in this case with the student loans, I don't want the consumer to have to feel the blunt of a decision that we made here. Where it's difficult for the servicer to find someone to service their loan and then
No,
there's
it's
some
it's an easy thing.
unforeseen consequence to that, to the consumer. All right, thank you. Are there any questions? No, thank you, Matt. We appreciate it.
Thank you very much. Have a great day.
Next, we have George Herman, the Chair of Windsor Federal Bank.
Good morning, co-chairs Doucette, Miller, ranking members Berthel and Delnicki, and the members of the committee. I'm George Herman. I'm executive chairman of Windsor Federal Bank, an approximately $900 million institution headquartered in Windsor, Connecticut. We're a mutually owned federal savings bank. And we have 105 employees. I am also chairman of the Connecticut Bankers Association's Legislative Committee, and I'm here to testify on behalf of the CBA on Senate Bill 1255 regarding the State Treasurer's Community Banking Program, as Matt had just mentioned. The CBA has submitted written testimony, but I wanted to voice my support as well. The Community Banking Program was established to support Connecticut's community banks and credit unions, and to enhance the ability to promote economic and social health of the communities that they serve. Senate Bill 1255 will clarify that out-of-state and federally chartered institutions like ourselves will be allowed to participate, and credit unions will be allowed to participate in this program. You know, when we say we're federally chartered, we're just regulated by the federal government. We're a mutual institution that was founded here in Windsor during the Great Depression, and we're owned by our depositors at this point. We believe access to the program for these community financial institutions was unintentionally omitted under the 2023 legislation, and would want to expand this program. By ensuring that institutions can participate in this program, the bill will maximize its overall impact on the increasing pool of eligible deposits and the number of communities and residents that are served. And I wanted to just thank the community, the committee for the opportunity to testify in support of 1255. And I also just wanted to, in my role as chairman of the legislative committee, I wanted to just mention about House Bill 6877, which is takes away a long-standing but out-of-date requirement for state chartered institutions, capitalized state chartered institutions, to have to make very extensive filings whenever they want to improve or open a branch. And in this day and age, when everybody's concerned about branches going away, I think that it's in the best interest to try to do things that will allow this to move forward. This is for well-capitalized institutions. Just a couple of quick examples, and I think Representative Delnicki and Representative Doucette are familiar with a couple of projects that we did. And we do not have to go through this as a federally chartered institution. We renovated a historic building on Broad Street in Windsor. And if you've ever renovated a historic building, once you open up the walls, you have no idea what you're going to find. And that's what ended up happening as we went in. So there were cost overruns. If we were state chartered institutions, we would have had to gone back, refiled a fairly extensive application with the state just to cover that. The other thing was we built an office in South Windsor. The other thing in the state of Connecticut is if you turn around and you do something on old farmland, you never know what you find when you start digging around. So we had a little bit of a cost overrun on that and the same type of thing. So I thank you for my time. And if there are any questions.
Thank you for your testimony, sir. Are there questions from the committee? Representative Delnicki.
Thank you, Madam Chair. And I have to commend you on what you did with that historic building. It is over the top, from maintaining a crown jewel in downtown Windsor. And of course, when you came to South Windsor, that farmland, quite frankly, had been farmed with tobacco and corn, et cetera. And you're right when you speak to that, because the other folks in Evergreen Walk had a problem there. And the fact that you were federally chartered, you didn't have to deal with the regulations, which were well-intentioned, and I believe based on some things that happened probably 20, 30 years ago. So I just wanted to commend you on that and make a couple of comments pertaining to how far back that previous legislation probably was instituted.
Yeah, I mean, it's been $750,000 for forever. And I mean, I was chief operating officer going back 25 years ago doing projects. And even at that time, $750,000 was not a lot to try to build and do something. And thank you for your comments. We tried to keep the historic front of the building and still offer modern banking services. Became in the back door. So it was the same thing.
Thank you for your testimony. Thank you, Madam Chair.
Thank you, Representative. Are there any other questions? Representative Doucette.
Thank you, Madam Chair. Thank you, George. I did want to mention that as well, that was fortunate to get an invite to that ribbon cutting for that new branch in Windsor. That was an awesome project and a great example, I think, of what we're trying to do here. And we thank the CBA for bringing this forward. But it reminded me that you don't have your charter here in Connecticut, and we've talked over the years. We'd love to get you here, but maybe this is a good example maybe some flexibility that you have. Is there a analogous regulation under your charter if you wanted to do a branch renovation like that? Do you have to go get an approval? And if so, how does it compare to what we currently have?
We just have to file notice that we're doing it. Again, it depends on the financial stability and the capital of an institution. But no, we just file a very short application and have to make sure that we've gone everything with the state archaeologist to make sure that we're not doing something in a protected area.
Yeah.
But beyond that, we are not restricted.
Okay, good. Well, I mean, we're happy, I think, to make this change. We passed this through committee, sailed through last year, and hopefully sail through and get across the finish line this year, and that'll be bringing us, providing us the flexibility for our chartered institutions. And then on the other side of things, I appreciate you coming forward on 1255. Again, to talk about that, because, I think of Windsor Federal, as you know, Windsor Federal is my bank for my law firm business, and neighbor of mine over in South Windsor. I think of Windsor Federal as a community bank, and doing the ribbon cutting in Windsor at that beautiful building. It reminds you that it's an anchor of the community. But currently, you don't participate, you're not able to participate in that treasurer's program. So that too, I think, as a bank that is entrenched in the community here, I think is going to be a benefit to everybody to have you participating in that. So thanks for bringing that to our attention as well, giving us a good concrete example of how that change is significant and is going to help us. So appreciate your testimony today.
Thank you.
Madam Chair.
Thank you, Mr. Chair. I have a question. So with your renovations, there's no limit as to how much you can spend for renovations?
Correct. I mean, but let's be practical. We're running a business, and we want to make sure we're going to get the appropriate return on whatever we invest into any type of project. But it's not having somebody else tell us what we have to do. It allows us to make the business decision or what we feel is best for our business, for our markets.
All right, thank you for that. Are there any questions? No, thank you for
Thank you.
joining us today. Next, we have Jeff Gentis of the Housing Coalition.
Good morning.
Oh, you're online. Hi, Jeff. How are you today?
Good, thanks. How are you?
Good.
Thank you, Senator Miller, Representative Doucette, Senator Bertel, Representative Delnicki, and the other distinguished members of the committee. My name is Jeff Gentis. I'm a lawyer who helps homeowners defend foreclosures, and I'm here in support of House Bill 6878. This is a bill involving a statute of limitations. It is a bill that you considered last year and passed out of committee. We appreciate that you brought it back. My colleague Lorraine Martinez Bellamy is going to be speaking later about the bill as well. I just want to focus on a couple of aspects to it. One is this would address, from our perspective, the issue around zombie mortgage foreclosures. So someone who has a second mortgage that hasn't been heard from in years, that hasn't received any mortgage statements, nothing on their credit report, is likely charged off. And uniformly with our clients, they managed to survive the Great Recession, get a workout on their first mortgage, and often quite reasonably thought that the second mortgage had already been dealt with as part of that first mortgage workout, only to find themselves in foreclosure for double or triple the original amount that was borrowed, often by somebody who then not only are they bringing this foreclosure out of nowhere, but pay pennies on the dollar for this loan. I just want to talk about it in terms of the context of resources. These cases require discovery, depositions, trial in many of the situations. And a statute of limitations makes it much easier to figure out, is this a valid loan or not? Second, right now under foreclosure mediation, it's generally, can you afford a workout or not? It's not like traditional settlement conferences or mediations that we're used to as lawyers. It's very focused on the finances. And many times, like, homeowners can't come together with the table of, oh, I'm going to put $30,000 down or even more, and then pay an exorbitant amount per month to pay off this, zombie mortgage. So mediation is often unsuccessful in those, and for that reason. And the number of lawyers who can do that much legal work to resolve a foreclosure in the private sector, you need to pay the lawyers. And homeowners facing foreclosure who already are dealing with their first mortgage and paying that expense, paying another a lawyer to deal with their second mortgage is often just beyond their means. And in terms of nonprofit resources like what Lorraine and I do, we're at a point where there's at the fewest number of pro bono foreclosure defense lawyers since 2011. And it's just very difficult for us to take more than a handful of these cases at a time. So we appreciate that this bill could present just a bright line rule saying for the most egregious cases, if it's been 10 years or more since the default happened and you still haven't started a foreclosure, you're still not trying to foreclose, that's just too long. And it would bring us in line with New York and New Jersey. So with that, thank you for your time, and I'm happy to take any questions you may have.
Thank you. Are there questions? Representative Doucette.
Thank you, Madam Chair. Thank you, Jeff, for joining us. And we look forward to talking to Lorraine as well, because I think you bring a lot of valuable experience on kind of both a complicated and a under the radar issue right now. I guess for the benefit of the committee, could you sort of describe to us in your experience the average zombie mortgage foreclosure case that we're talking about? What is the loan that's being foreclosed? How much usually is it? And what is the duration of time that we typically see where this loan kind of falls off the radar completely and then comes back in the form of a foreclosure? And then, sort of what is what do the numbers look like on that? In terms of the amount of debt that's being foreclosed, the costs associated with it. We got a first mortgage, presumably in most cases there as well, that comes into play in terms of the whole financial picture. You just give us a perspective maybe and dumb it down for a caveman lawyers like me about what it actually looks like on the ground.
I'm more concerned with not over talking, so I appreciate the request for clarification. A typical is somebody who lives in an area that was already hard hit by the original foreclosure crisis. Who, we have a couple cases now in our hopper. One woman, single woman, had a household, borrowed $60,000 as part of her second mortgage 20 years ago. The mortgagee is now claiming $162,000, including costs and fees. And that was after 12 years of never contacting the homeowner, just jumping up and saying, "Oh, congrats! Now you have some equity, and we're gonna take it." We have another where she borrowed $39,000. She's up to 108. Those coincidentally are the same lender. And they'd gotten modifications back in 2010 and thought with the huge increase that they had in their original balance in their first mortgage and the modified balance that the second mortgage had been part of that. And, if nothing's showing up on your credit report, you're not getting any mortgage statements. It's a pretty reasonable thing to ask, or a pretty reasonable thing to think. And so, and the reason they show up is, the second mortgage, and most of the time the original holder abandons it. There's no equity. The person was unable to pay. And so they walk away, they sell it off in the debt market. And then somebody sits around and, some of the people who benefited from the pandemic are often the people who purchased these mortgages and then saw the huge rise in housing prices. And now somebody who had a house that was worth 300 and they had a first mortgage that they've managed to pay down and start getting equity on, and they get it down to 200. The second mortgage shows up and says, "Okay, well, now your house that was worth 300 is now worth 400, but we're going to gobble up, the work that you've put into paying this mortgage down and the rise in home prices since, and we're going to foreclose based on that equity that you have." And the typical workout offer is a 5-figure down payment with several $100 a month payment over the course of the next, 20 years or so.
Right. And you talked a little bit about, my second question for you is going to be the volume that you're seeing on the docket. I think you're tapped in as well as anybody in the state to foreclosure dockets throughout the state. And the question came up, I think when we were talking about this, about, what are we actually talking about in terms of volume of these things? Because frankly, I don't think anybody really heard the term zombie mortgage. We had this bill last year and worked on a little, and it was it's still in development then. But I gather that now it's become a very significant issue, and there's a high volume of these. I mean, you talked about how I think there's equity now because of what's happened in the real estate market. A lot of these are from back, pre sort of foreclosure crisis, and then they went away, and now they're resurrected because of equity. But it's fair to say that you're seeing a significant volume, that even from when we were here last year talking about this, that there's been a big uptick in the number of these zombie mortgages being foreclosed?
Yes, I think I should have, before this hearing, I could have run a search on trying to figure out how many times the word zombie appears in our database for intakes, but I think we're north of 100 now. So it's at least dozens that are pending. The people who make it to us are usually somebody who's already talked to another referral source. So I can't say we're talking to every single person who has a zombie mortgage foreclosure, but I would say several dozen are active in the courts, maybe hundreds. We've probably done 100 intakes over the past 2 or 3 years. And they make up a disproportionate share of the situations that mediators can't work out and yet have like a legal hook on them, more than just, I don't have, I'm out of work, or I went through a divorce, or some death in the family where like income's just not there anymore. And this is an issue nationally. And one difference with Connecticut is because we lack a statute of limitations, we can't use certain kinds of federal law to leverage in our client's favor and try to get some kind of resolution that way. Because right now, federal law and federal regulations issued by the CFPB a couple of years ago are tied around a statute of limitations. So without that, we're just missing another arrow in our quiver.
And then the last question I want to ask you is about the statute of limitations. This bill establishes 10 years as the period after which a default, after which the last payment occurred. Being the statute of limitations. Talk a little bit about that. Do you think that's an appropriate? Does that play out? Is that how you see a lot of these cases playing out? I would imagine, we're talking 10 years ago, 2015. So a lot of these mortgages maybe, started defaulting perhaps back in that period, that sort of post, financial, recession period of 2011 to 2015. So I think it probably anecdotally would be fair to say that that's going to cover a lot of these mortgages that they would have defaulted, or the last payment would have been made within that time period. But talk a little about the statute of limitations and the 10-year time frame, and how you think that that works, whether that's sort of an appropriate place to land.
Yeah, I think that's right. I think most of the payment defaults that we see are from the sort of the Great Recession era, 2009 to 2011. And 10 years would not make Connecticut anywhere near the most, the shortest time frame. There's these states with, 6 years and durations like that. And so 10 years would catch the worst offenders and also make it easier to address those. And then the situations that may be a little bit more complicated, you could leave those to our office. But the 10 years of statute of limitations would make it like a nice, clear rule. And I think it would benefit the vast majority of the people who are facing these foreclosures at this point. It'd be great to have.
Okay. Appreciate it. Thank you, Madam Chair.
Thank you.
Thank you. Senator Barthel.
Thank you, Madam Chair. Jeff, thank you for your testimony. Just to piggyback a little bit on some of what Representative Doucette, Chairman Doucette spoke to. I think you said that you think there's about 100 or so of these types of zombie mortgages that you think may be on the system now, which was my question as well. I was concerned about the total. My other question is this, and maybe you know the answer, maybe you don't, but who is actually the lender that is coming to to try and collect on these
Mhm.
mortgages. Now, have they been sold to another party, or is it still the original, pick, any town community bank that wrote the mortgage originally, and or have they been sold to other servicers?
Yeah, that's a great question. Thank you for bringing that up because it's something that we should highlight. Zero of these come from local community banks. Most of them were originated by a national bank that then charged off the loan at a certain point after non-payment and then sold off the asset. So it took it off its books and then sold off the asset. And then most of the time that asset's been sold more than a few times. And if you have gone into I'm hoping there's a reference that someone on the committee will get, but you can go into sort of the dark world of podcasts, sort of do it your own financing and YouTubes, and you get folks who I'm just going to speak bluntly, and hopefully I'm not offending too many people, sort of finance and real estate bros who view this as like, oh, I'm in distressed debt now that I purchased a mortgage loan in default, and ooh, I've got it's a secured play, and it is and the other component is compared to the first mortgages where you've got Fannie Mae, Freddie Mac, FHA, you've got a series of protocols that you can figure out, okay, are you aligning with these or not? Can we work something out based on what a community bank would do, what somebody else would do that trying to get a workout out of this? You have no idea what these guys are going to do. And it's all over the map. You have people who might actually work out a deal with you. You explain to them, hey, the 78-year-old immigrant's house that you're foreclosing on isn't worth what you think, and here's why, and maybe we can work something out. Other times you end up on appeal.
Yeah,
You
okay.
have to take it all the way through. So it's largely smaller, sort of like poor man's private equity type investors or hedge fund investors or people who can get involved with 5, 6, 7 figures of investment as opposed to, having to go raise $1 billion like the Carlyle Group or something like that.
Okay, thank you. I appreciate that. And what it brings my thoughts to are that it kind of makes sense in terms of the bill that's before us that maybe we should be in some way looking at these lenders or the people who are trying to collect these zombie mortgages more like collection agencies
Yeah.
versus a bank, and they should be subject to perhaps some of the more strict regulations regarding the collection of debt. So just thinking out loud, and I'm glad that we were having the conversation, but it does seem as though it's quite unfair that the statute of limitations issue alone, and your comments regarding, the way property values have increased substantially in Connecticut over the last, I guess, 5 years primarily, maybe 6 or 7 years, and that these lenders these people who are trying to collect these zombie mortgages have very specifically and intentionally looked to see that now there is equity in a house and now's the time to grab it. So, all right, thank you. I'm rambling on a little bit. Mr. Chair, Madam Chair, thank you for the opportunity to ask a few questions.
And I appreciate that question again, Senator. Thank you.
Thank you. Are there any other questions? Jeff, I have a question. How
Sure.
far, in your experience, how far are some of these loans going back?
They're usually originated in the aughts. So you usually have somebody where there was it's usually not a separate home equity loan. It's usually in terms of like, it's not like somebody who's like, I need to go, borrow money to send my kids to college or to pay for repairs. It was usually a piggyback loan, a part of a refinancing, less frequently with a purchase, but usually someone was refinanced where the first mortgage was 80% of the value, second mortgage was 20% of the value, and that 20% chunk is what we're talking about. So that's usually the scenario we're dealing with, a lot of 06, 07, 05 type originations.
So this issue was brought to me at the end of 2023,
Mhm.
and that's why we brought it to the committee. this person explained to me, I guess during the Obama era administration, there were mediations. And so they had assumed that the two loans were merged. He said that he thought that it was forgiven, that second one, because
Mhm.
they treated them as a package.
Yeah.
So for someone to come back, these predators, and I'm going to call them predators, to come back 20 years later, almost 20 years later, to say, hey, look, you owe me money. And there's no way of individuals tracking to see how much the payments were, to look
Right.
interest, none of that. So there's no way of anyone trying to or understanding or try to figure out if what they're asking for is legitimate. And you go back, you talked about attorneys. I mean, that costs money and monies that individuals don't have. So my question to you is this: I know that New Jersey, you said New York and New Jersey, aren't there yeah, limit of statute limitation? I mean, the years of statute limitation, aren't they less than 10 years? Do you know?
Uh, I think New York might be 6, but I'd have to recall. I know Florida's 6. I'd have to go back and look to be sure, but I can get that information you sent her offline.
So thank you for that. And I'm glad you brought up those two states. And I personally would like to see our law go to 6. I still think 10 years is too long for a person to have a person out there, a loan out there, and a person not know that they own it. And so thank you for your testimony and thank you for the work that you do for the residents of this state, because not only do you help them with loans, but you also help with housing cases. And I really do appreciate your agency. Thank you.
Thank you. And I appreciate Lorraine telling me offline here. I have 2 screens. One is Lorraine sending me this message and the other is this Zoom. She's saying 6 years for both New York and New Jersey. So that's it's great.
All right. Well, thank you for the testimony. Thank you for highlighting that. Are there any other questions? All right. Seeing none, Jeff, thank you so much. And we look forward to hearing from Attorney Bellamy.
All right, thank you all so much. And we're happy and willing to work with all the stakeholders on this to make this happen this year. We really appreciate it. Thanks.
Well, your agency, the organization is always willing to help, so we appreciate it.
All right, thank you.
Next, we have Art Corey from the Connecticut Bankers Association. I heard that you're a pair, so you can come up together. I think you're in charge, Tom, so you're in the hot seat since you're in charge.
I think it's good afternoon, Madam Chair, Mr. Chair, Ranking Member Delnicki, Ranking Member Berthel on the Zoom call, and members of the committee. It's great to be back before the Banking Committee. We're just going to talk about 4 bills that we've highlighted here. We have submitted written testimony online on all those 4 bills. But I'm going to start first with the one that Mr. Herman testified on, which is Senate Bill 1255, the Community Banking Community Credit Union Investment Program. The short version is, I'm not going to repeat what George said. He did a very good job at it. Good bill ought to pass. We're glad that it's being expanded. And we, as George, think that it was just, an unintentional omission with regards to including federal banks, and also federal credit unions would be included in that as well. The other 2 bills are, first one's number 2 and number 3 are Department of Banking bills. We are working with the Department of Banking on those bills. We basically will be back to the committee in a very short period of time with hopefully nothing to report other than we're neutral on those bills, but they are very detailed. So we have to go through them in detail and make sure there's no unintended consequences associated with them. Next bill is number 5, and that is the first time homebuyer savings account and related tax deduction and credit. Once again, this is also a good bill and ought to pass. And there's a number of reasons, as I think you folks know already. This is obviously being brought up from last year as well. And I think really the key is that, it's a tax advantage savings program. It really helps out dramatically with down payment and closing cost. And in this interest rate environment, and also considering the cost of homes these days, down payment assistance is more important than ever. CHFA does a great job. Let's not forget that they do a super job with programs that they have. But this is a good way, especially in conjunction with the financial literacy programs, which are now happening out there in all the schools across the state, to essentially give people that want to save for a home as soon as they get their first job, let's set up that savings account to essentially go towards, helping to acquire a home and pay that, which becomes more and more expensive, that down payment that goes into it. And I do love the fact that it also covers closing costs as well. Once again, good bill, ought to pass. Next up is what George briefly talked about, and you folks obviously explored a little bit, and that's 6877, Banking Commissioner's approval of real estate improvements. Basically, we call it the application bill. Once again, that is a great bill, which we believe should pass. It was here before the committee last year, and it really does eliminate the need to for well-capitalized institutions, well-run institutions, and that's at the purview of the commissioner, to avoid having to go through a very lengthy and expensive application process should they want to essentially do branch improvements. And I think George really said very well that, we want to keep branches in locations that we have them. We want to continuously keep them up to snuff, keep them improved for the good of obviously our customers and also the community that they serve. And this would make it a lot easier and less expensive. I would think of it as basically getting rid of unnecessary regulatory burden. The commissioner is always there. They always have the ability to pick up the phone and check with George Herman or another CEO out there as to what they're doing with regards to their bank. So it's not like this is, being done out there where nobody's keeping an eye on it. Not to mention that our bankers are pretty responsible when it comes to essentially doing branch improvements. Branches are actually shrinking in size in comparison to the old branches. As Representative Farley can probably attest to, the old branches were probably twice as big as they are now. You're probably looking at like maybe 1,500 square feet for your new branch, which goes out there. But once again, this has to do with renovation. With that said, my time is up, and if it's okay, if anybody have any questions about what I talked about?
Tom wants to know if you had any questions.
Sorry, Madam Chair.
Thank you, Madam Chair. And I want to thank you for your testimony pertaining to the first-time home buyers savings account setup. Now, you made mention in your testimony written pertaining to multifamily homes or multifamily units. How would that work?
So a lot of people are out there, first-time home buyers. Multifamily is a great way to get into the housing market. You have potential rents that can supplement your income to essentially make that work. And that goes into the underwriting decision as banks or lenders take a look at, whether or not you would be able to essentially afford that. So that would directly play into someone being able to essentially purchase a multifamily. And multifamily is typically defined as 1 to 4 family.
So you could foresee a situation where we might want to change things a little bit to allow multifamilies to actually be able to purchase through a first-time home buyers program, multifamily home, multifamily unit.
Yeah, that would be a great idea. Quite frankly, now that you're bringing it up, there's also a number of multifamilies which are 6 families, especially in, the urban areas. So essentially giving somebody the opportunity to use that. Obviously they would become not only a homeowner, but also they would be investing in that and in their community. So I think it's a great idea.
I appreciate that commentary there. And the alterations and improvements in savings institutions in Connecticut, I have to make that comment again about what Windsor did over there. They preserved a historical building, and I'm sure there's a number of banking institutions that have historical buildings currently that might want to improve them, yet they're concerned over having to apply to get permission to be able to go above a certain amount. what do you foresee? Should there be any kind of restraint there on what they can spend without getting permission? Or would it be a situation where you wouldn't necessarily have to have a limit per se based on, say, the financial security of the institution?
So every year, certainly the state chartered institutions, they get audited, they get examined, and the examiners take a very close look at real estate owned. So in that process, they're going to take a look at what was essentially put up, if there was, what the renovation was, if there was a new branch that was built. And they have the ability to do that at any time, but they do it on a regular basis during examinations. So we have no issue with them essentially going through that process, taking a look at, what was spent, and what was produced basically for the dollars that are there. Another good example I think I should bring up on renovations is, I mean, it's not just necessarily renovating a branch to do business. In many cases, we've got banks that renovate banks and basically create a community space, a community room where it can be, basically used by anybody who wants to use it, from, a nonprofit group, whatever the case would be. So there's a number of different things that branches are used for besides just conducting business.
Well, thank you for your commentary and your comments, and I appreciate them. And hopefully we can get something done here on the first-time home buyers. And I do like the idea of being able to do it with a multi-family home where more than one family could combine their money so as they could actually purchase a multi-family unit, multi-family home. That's a great idea. Thank you, Madam Chair.
And it's my understanding when I talk to some of my friends and their grandparents, that's what people did. They pooled their monies and bought multifamily homes, and we don't do that anymore. And so I think the economy has gotten us to the point that we should consider doing that. Banks need to be a little more flexible in doing that. Art, did you want to add something?
Thank you, Senator. I just wanted to add that the provision isn't going away entirely. It would be limited only to banks that are adequately capitalized and have no enforcement actions, no regulatory issues. So it would be those banks that would be relieved from this regulatory burden, which again, the federally chartered counterparts do not have. And there are a number of things that banks do to spend money on that, the Department of Banking, I think, I don't want to speak for them, but doesn't want to, be involved in the business of how a bank spends money. As Tom said, those if there are questionable decisions, they can be, sort of reviewed afterward. But they have boards of directors that exercise oversight, and so I think the department agrees, because they haven't objected to this proposal last year or this year, that it's a requirement of a sort of a bygone era, if you will. Thank you, Senator.
Thank you. Are there any questions? Any more questions? Senator Berthel.
Thank you, Madam Chair. Tom and Art, thank you for your testimony. I have one question regarding the first-time buyer proposal, the bill and the changes, and I don't know if it's in there. I've read the bill a few times. I don't recall, but is the person who has this account, are they required to live in the home that they're buying?
I believe they are, but I'm not positive on that. Art, do you remember?
Yeah, I think that there is a primary residence requirement. We want to take the opportunity to recognize the CBIA, Pete Myers, who's done a great job, and Chris Davis of championing this bill last session, previous sessions, and certainly this session. They are perhaps maybe slightly more closer to it than we are, and I think they could probably answer that question. But that's my recollection anyway, that this is not for investor properties.
Okay, great. Yeah, that you and Art, thank you. You anticipated my next comment that, I like the program. I think that it will open up doors and opportunity for more people to acquire home ownership. But I don't know that I think we have to be deliberate and careful about making sure that we're not creating necessarily the investor property opportunity here, and that we're looking truly to help first-time home buyers. So, okay, thank you. Thank you, Madam Chair.
Thank you. And to that point, Senator Berthel, I think that that's something that we as a committee, we need to look closer at, as well as that also putting a limitation, a requirement of how long you have to reside in the unit, so that it's not a year and then you go your merry way and it becomes an investment.
Yeah, I agree, Madam Chair. Thank you. Yeah, it's a good conversation for us to continue to have. Thank you.
Art, did you want to add anything before we leave?
Senator, we were also going to provide some, just a brief testimony on the mortgage foreclosure bill, but, I think we're, beyond our time, but I'd be happy to answer any questions on
All
that.
right. Thank you very much. Any questions? For the 15th time, Representative Representative Delnicki.
Just very briefly, Madam Chair. I'm going to ask you folks if you know of any language that would be an adjunct to preventing some person coming in and investing and creating a situation where it wouldn't be first-time home buyers per se, as we're thinking of, and that it wouldn't be somebody coming in as an investor to actually purchase units and use that program. If you know of any language that would be a benefit. And you don't have to have it right at this moment.
Thank you. I would suggest taking a look at the CHFA program, because I'm sure that does have quite a bit of criteria requirements in it. And that could be a great starting point. We'll look at it as well and obviously get back to the committee with, anything that we find. But thank you.
Thank you. Are there any other questions? Seeing none, thank you, Art and Tom.
Thank you.
Thank you.
Okay, I think I'm going to jump in here for Senator Miller and call Pete Myers next on our list to testify. Welcome, Pete.
Thank you. Well, I could easily just say good bill ought to pass, similar to they did on first-time umpires. Good morning, Representative Doucette, Representative Delnicki, Senator Berthel of mine, and Senator Miller, and members of the committee. My name is Pete Myers. I'm a senior public policy associate at the Connecticut Business and Industry Association. And I'm here today to echo the comments of the Connecticut Bankers Association in support of the first-time homebuyer savings account bill. We are very thankful for the committee to raise that bill once again this year. We believe that this is going to help to solve or address two of Connecticut's major issues impacting our state's economic growth, that in workforce growth and retention, and in the high cost of homeownership and high cost of living in our state. The way this bill would function is it would allow for a first-time home buyer to make contributions to this account, receive tax benefits for doing so. Additionally, this would also create the opportunity, and this would be unique to Connecticut's first-time home buyer savings account, to allow an employer to put some skin in the game and make contributions to this account to help recruit, attract, and retain employees that are coming out of our great trade schools, our great colleges, our great universities, and our great high schools in the state of Connecticut, and keep them here. And really, we also view this as a competitive advantage against our competitive states, like looking at Massachusetts, Rhode Island, New York, who are also struggling with the high cost of home ownership, with the shortages in the labor market. This is something that would give us a leg up on those states. And they have great colleges, great universities there, great trade schools, not as good as University of Hartford in Connecticut, of course, but this would give us a chance to compete against those schools and get those students to come right out of school there as well. And additionally, I want to point out in closing that if you look across the country, there's been other first-time home buyer savings accounts that have been put in place, specifically in the state of Iowa, where it's been utilized, but the utilization has been lower. We feel that by allowing an employer to contribute to this account, receive a tax benefit for doing so, really incentivizing them, you're going to increase the awareness of the account, and you're going to increase the utilization of the account. And we really think that that is what sets us apart in the most important part of this. So in closing, I also want to say we are also in support of House Bill 6877, which is the removal of the requirement for bank expansion as well. And happy to take any questions.
Well, thank you, Pete, and thanks for your work on this and your persistence in bringing it forward. We've had this bill, as you know, and the committee passed it through several times now. It actually keeps getting better, I think, because when you dust it off, as we have been, to look at it, Again, we go back through and we potentially improve it. One example of that, of course, is your idea of the employer contribution, which I think is great. And actually, I think I hear that in the market that is becoming more commonplace. And talking to some mortgage lenders too, who see that coming into play, where employers want to provide those incentives, and that goes into the underwriting on the loan and everything. So that's a very sort of current issue. And I think it's good that we've incorporated that in the bill. I want to take the opportunity to ask you, though, you heard the colloquy there and about the multifamily, or the potential to, it would seem to sort of make sense to match it with sort of CHFA's first-time home buyer guidelines, which include 1 to 4 family. I also believe there's something in there about certain targeted areas. So and that goes to the determining who's a first-time home buyer. So
Yes.
it's somebody who hasn't purchased a home within 3 years, I think, or it includes target areas as well.
Sure.
So not to put you on the spot, but you can certainly get back to us, because these are ideas are coming up on the fly here. But have you thought about that? Would like you to think a little bit about that and maybe work through that issue with us.
Absolutely. And thank you, Representative. And I think, as you said and started off there with how this bill keeps getting better and better, I think this is another piece to add to that. To use Representative Delnicky's quote last year, the cake is ready to come out of the oven. It's now we're icing the cake. It's another great point to add on there. We would be supportive of adding multifamilies on there. I think to go to the point of attracting young professionals coming to Connecticut. It's something that a young professional might not be able to buy their first regular house yet. Maybe doesn't want to be in a condo, but a multifamily coming out of the community of or a college or a trade school where they're with people around their age. I think it could be another great benefit. For somebody myself, I would have loved that experience coming right out of school.
Yeah, it's a really smart way to help finance your first house. I've seen it before, and it's not utilized that commonly, but to buy a multifamily, live on one side, rent the other, I think is a great investment for a smart first-time home buyer. So yeah, would appreciate you maybe looking at that a little more. Obviously, to Senator Berthel's point, we wouldn't want it. We want to make sure that it's not just for investment purposes.
Us as well. Yes.
But something to think about.
Yeah, I also want to point out too, oftentimes, if you look around like the great city of Bristol, Connecticut, the downtowns, there are a lot of multifamily housing there. Mayor Caggiano there has done a really good job of revitalizing the downtown, and this getting more young professionals living in those downtowns, patronizing those businesses, I think would be a good step in the right direction there as well.
All right. Any other questions for Pete? Representative Santos.
Thank you, Mr. Chairman. I had 2 questions. You asked the first one already about the multifamily housing there, and I appreciate the answer. That was very thorough, and I think it is a great opportunity for folks, especially young professionals we're talking about, student debt, and they're coming out of college with a bunch of debt, and yet giving them a tool that can help them reach the dream of home ownership is a good opportunity in my opinion. But one of the things I worry about with our state is, are we doing enough to keep young professionals here? Once they go to college here, they grow up here. I find that folks younger than I am, although I still think I'm in my 20s, I'm not. 20-something-year-olds, young 30-year-olds who are just starting out in life. I'm finding folks in that age range, my age range, would move out of the state, right, for whatever reason, and they're finding better prospects everywhere or anywhere. What we need to do as a state, and I think we've taken some strides in doing that, is finding ways to keep them here, right? So you think that this is an opportunity or a tool that we can use to attract young professionals?
Absolutely. I do think it is a tool. And I agree with you. Attracting young professionals, we're educating them here. We're investing a lot of money through kindergarten, through high school, through college. We might as well try to keep them here as well and not just let them off the hook after that. And I do think this is a good tool that could be utilized. And I think a lot of employers, especially in the manufacturing space, who are looking for employees right out of trade school, right out of high school at some point, really, okay, we're going to help. We're going to make this commitment to you, and we're going to contribute to this account, and you can plant your roots here, invest in the local community by buying your first house here, hopefully with a locally chartered bank as well, and make a commitment to stay in Connecticut. We think it would be a great tool.
Yeah, and I think that that home ownership creates a vested interest in the community, makes
Absolutely.
people set roots here, right? And that's only beneficial to our communities. It's part of a tool that we can use and employers can use to retain good talent and attract even better talent. So thank you so much for bringing this bill again this year. I appreciate how you've been shepherding it through, and I look forward to hopefully its passage on the floor.
Yes,
Thanks.
thank you very much.
Thanks, Representatives. Rep. Delnicki.
Thank you, Mr. Chair, and thank you, Peter, for coming forward, because I look at that extra dimension of employee-employer relationship and building a loyalty with the employee and a level of loyalty with the employer by actually being a party to the first-time home buyers process. I think that could yield some tremendous results and create a very stable workforce. You know, a lot of people, they jump around from job to job. With a situation like this, and that loyalty between the employee and employer and employee, then creates a level of stability that might not be there without something like this. So that little dimension there, I think it's excellent. I think that the public hearing here is yielding some very good results on a piece of legislation whose time has come. So thank you for your testimony, and I certainly appreciate it.
Yes, thank you.
Hopefully
Representative.
we get it across the finish line.
Yes, and thank you for your continued support on that too. We really appreciate both of you.
Okay. Seeing no other questions. Thanks, Pete.
Thank you.
Appreciate it. All right. Next on our list, number 6, John DiOrio, who I believe is online with us. Yes, I see him there.
Sorry about that.
No problem, John.
A couple of things on 1257. I have submitted testimony both this year and last year about 36A 492C. I don't want to spend too much time on that today because I think that testimony explicitly spells out the problem and the fix. I've seen OLR communications on the very issue, so I think the understanding there is pretty solid, and I hope that if this does go through this year, that 36A 492 fix is enacted as part of the adjustment to that statute. My bigger concern, candidly, is the shared appreciation agreements. I attended the CSBS conference and was literally shocked by the presentation that I saw and the actual vendors of the product saying things like they can't collect HMDA data. They're unable to collect HMDA data. So why would a lender of any type, especially one giving a mortgage, not be able to find out the racial composition of the people that they're lending to? It's an absurd assertion, and it's a huge red flag. And as we contemplate zombie mortgages, which were just testified to by a very qualified source, these are begging to be the future zombie mortgages. And the way to do it is as Massachusetts has implemented the program. I have shared that with both the commissioner and the chair of this committee. It is a great public product if it's administered by a state or federal agency. It is a dangerous predatory product if it's in the wrong hands. And I beg you not to pass that piece of 1257 as written. And that's all I have. Thank you.
Thank you, John. Thanks for bringing that issue up. So what would be your suggestion? Because, you know, the 1257, the piece about shared appreciation, adds some disclosures, and your point is a good one that I'll have to look into some more. I wonder if that has been discussed, because I know the department's had some conversations with some of the industry players on this to get their feedback on this. This was something we had in the bill last year as well. So what would be the change you'd suggest to just add that to sort of the list of,
Honestly, if I was, so I have experience with this product. We did shared equity and shared appreciation mortgages in partnership with HUD in response to the financial crisis. So I understand how they work. And I understand in that context, they can be great accounting tools for state or federal agencies. And the danger of things like a zombie mortgage are curtailed by the fact that if Mr. Gentis is dealing with HUD or CHFA as opposed to a debt collector, as Senator Berthel has correctly dubbed these people as, the only way to do it is, in my view, if consumer protection is your number one goal, is as Massachusetts has. And I have submitted that language to you, Mr. Chairman, and I have also posted it to the website. And listen, it's a great tool. There are actually ways we could deploy it in our community banks. There are ways that we can deploy it through the CHFA. There are ways we could tie it into that first-time home buyers piece of legislation that you were just talking about. There's a lot of good use for this product. But when I hear lawyers for the industry saying that they can't collect HMDA data, that's it for me. That is the most unreasonable assertion I've heard in a long time. And there's only one reason not to collect HMDA data, and that is you don't want the racial profile of your portfolios to be transparent. So if you do it as you are suggesting, by the way, you have this, I think it's 36A 678, maybe there are even some regulations written on this one. If you're going to allow these mortgages that Mr. Delnicki has already pointed out, you can't calculate a reasonable APR on. I don't care how you try to jigger around with that. It's you can't get to a number that is realistic. If you're going to utilize the product, I would do it within government structure only. Otherwise, I wouldn't allow it.
okay. No, it's a good point. I appreciate you highlighting that for us. Any other questions for John? All right. Seeing none. John, thank you for your testimony.
Thank you, gentlemen. Have a great day.
You too. Next, number 7 on our list, Mike Alperts from City Savings Bank, who's joining us online. What's wrong, Mike? You didn't want to come back to your old haunt here at the Legislative Office Building?
I think I'm ably represented, co-chairman, by my state representative and my state senator. So I'm trying to avoid coming down there. I'd rather actually be down there today than dealing with the budget that I just had to pass. But it is my pleasure to be before you today. Good afternoon, honorable co-chairs, Representative Doucette, Senator Miller, and ranking members Delnicki and Senator Berthel, members of the committee as well. I am Mike Alperts, President and CEO of Jewett City Savings Bank. We're an approximate $443 million bank located in the Jewett City borough of Griswold. I do appreciate you raising the concept of adjusting the requirements of the Banking Commissioner's approval of bank branch improvements as contained in House Bill 6877. And there's been some testimony on this already, so I'll be brief in my comments. As you know, present language creates a level of regulatory burden that I believe is on Connecticut's community banks that is, it's not fair compared to, what we have to compete with in terms of some of the other banks. Well-capitalized, well-performing banks like our bank. We have a tier 1 capital level of $63 million. We're under no open formal enforcement actions by the Banking Commissioner or the FDIC. We had actually last year we submitted to the Banking Commissioner a request for a branch improvement initiative. The total initiative was about $905,000. We pretty much gutted one of our existing branches and improved it with technology and outreach capabilities for our customers. It took about 35 man hours for us to complete that application. So The banking commissioner's charges to us were very modest. It would only cost us $500, but I bet those 35 man hours probably cost us almost $4,000. And I think George Herman, talked about this before, but sometimes these things happen. You've got to go back and get approval for some type of increased expenditures. I do thank the committee for raising this issue for public hearing consideration. I do thank the banking commissioner as well, who's in support of this initiative, the Connecticut Bankers Association. I believe that this language right now that we're looking at for HB 6877, it's a good resolution to the challenge. I do applaud your efforts last year. I wish it got across, the end zone last year, but this is a great time to be doing it, and happy to answer any questions that I can for members of the Banks Committee.
Well, thank you, Mike. And I appreciate your testimony. And just joking about you not coming down here. Appreciate you and the work that you're doing there in the community. And you answered what was going to be my question, because I know that you underwent renovation project that really fits squarely within what we're talking about here. So you illustrated, I think, pretty well what we're trying to do here in making this change and why it's a good change to make. And again, you're investing in the community by doing that and by improving your real estate. So we appreciate that as well. So thank you for your testimony. Thanks for bringing this forward. Rep. Delnicki, I think, has a comment or question.
Yeah, very brief question, and I'm not looking for a lot of details, but what kind of information did you have to provide that took you 35 hours to compile?
Yeah, thank you for that question. There's a lot of information that relates to the budget that we're putting together, and information on the historical nature of the bank. But most of it dealt with the budget, the number of branches, historical information about the finances of the bank. The bank itself, I think, as we've heard testimony from I think Tom Mangiello and Art Corey talked about it. The bank leaders, I mean, we're governed by a board of directors that is very astute and wants to make sure that we do the right things for our customers. But, we provide to the banking regulators, both the FDIC and to the Department of Banking Commissioner, a lot of information on the status of the health of the bank, the financial health, in the call reports that we have to submit every quarter. So this is public knowledge. And then we also are well examined every 18 months. There's a safety and soundness exam that's done either by the FDIC for us or the state banking department. So we're actually up for the state banking exam sometime in the second quarter, we believe. And the regulatory agencies look at these exams, they pick up on them, they make sure that things are healthy. So a lot of that information that we submitted in the application package, Representative Delnicki, it was kind of duplicative to to what is available, but it is what we have to do under present language. So allowing us the opportunity to not have to do that would be much appreciated.
Well, I appreciate your coming forward here, and I did some quick calculations and just guessing at what your hourly compensation is worth, and it's well over $2,000 worth of time thinking about that. I mean, come on, that's a huge amount. So again, thank you for your testimony, and I appreciate you coming forward. Thank you, Mr. Chair.
Thanks, Rep. Delnicki. Seeing no other questions, Mike, we appreciate your time today and hope to see you soon.
Absolutely. Thank you.
Take care. Okay. Next on our list was Tom Mangiello, who we already saw. So can stay right there, Mr. Mangiello. You fulfilled your duty for today. Following that, number 9 is the aforementioned Lorraine Martinez Bellamy from Connecticut Fair Housing Center, who is online with us. Afternoon, Lorraine.
Good afternoon, Representative Doucette, Senator Berthel, Representative Delnicki, Representative Santos, and Senator Miller, if she's back. My name is Lorraine Martinez Bellamy. I'm an attorney at the Connecticut Fair Housing Center and have been practicing there for the last 12 years. I'm testifying today in strong support of House Bill 6878 regarding the proposed statute of limitation on mortgages. The bill would help middle-class homeowners who survived the Great Recession and are now facing potential homelessness because of these long dormant second mortgages in largely urban areas in the state. By setting that 10-year statute of limitation, it would, like Jeff said, would address the worst of the debt collectors that we've seen. And I wanted to focus my attention a bit on the point. I think Jeff mentioned it briefly, and maybe some of the opposition has mentioned it as well, that we have a very robust foreclosure mediation program that could help these homeowners that are in foreclosure. The point I want to make about the mediation program is that the majority of the cases in mediation are first mortgages, and the majority of first mortgages are insured by the federal government, by FHA, by Fannie Mae, by Freddie Mac, by VA, and those agencies set very specific loss mitigation programs to help homeowners keep their homes and be able to afford a new mortgage payment. The second mortgage holders that we are concerned about and that we have been helping homeowners litigate against and defend their foreclosure cases, they are not obligated by any agencies to provide any settlement at all. As Jeff mentioned, they do often offer loan modifications, but these require $20,000, $30,000 down payments. And they're asking that of people that are largely now in their 60s. Some of them are retired, some of them are disabled, and could never, don't have that money to bring to the table. In addition to those down payments, we've also seen them offer high interest rates or higher than market interest rates on those workouts, as well as balloon payments that come due later on. And often these callers and these people we speak to and sometimes represent, they are completely blindsided by these foreclosures, and the foreclosures can force them to become homeless if they can't come up with a solution. Everyone now, or most people we speak to, have significant equity, so they can be forced to eventually the home be sold at a foreclosure sale, and these folks become homeless in the process. Another point that I wanted to make that you all kind of got into with Jeff was just in the litigation of these cases. I myself have a handful of them that I'm litigating. I have spent 80 to 100 hours on a couple of these cases, and we haven't even finished discovery. So they require significant resources, and they also require attorneys to know how to litigate abandonment defenses. And there's not many of us in the state. So it's a function of there not being enough attorneys, people not having the funds to be able to defend a case that's that complicated, that's going to require that much manpower. And I believe that setting a statute of limitations is going to help us address the worst of those that have been dormant for 15 years, which I see often, 10 years, anything longer. And for the ones that are below that, we would then have more resources to be able to help those homeowners. And I'm happy to take any questions that have occurred to you since Jeff spoke to us all.
Okay, thank you. There was one question that we didn't get into with Jeff, and then we may have had discussions with various stakeholders when we had this bill before us last year, and that is sort of the question of the retroactivity of this statute were it to be enacted. This would, the whole concept that we're talking about here is sort of looking retroactively, right? In terms of, a current foreclosure for a old obligation. And I don't know, again, if you've done research in the other jurisdictions that do have a statute of limitations, which, operates in this respect. If we were to enact this, would it cover, that big sort of glut, what we think is a glut of these zombie mortgages back to that period of the Great Recession.
Yes, they would. The statute would, unless the language accepted it, or, you know, the legislative intent showed that it wasn't meant to apply retroactively, left as is. It would apply retroactively, and it would cover that period of time, usually between 2005 and 2007, where these zombie mortgages that are now popping up again were written. Most of them, as I look at people's, you know, land record, I look at the complaint, most of them were written within, originated within that 2-year time period, which would be covered retroactively by the statute as written right now. Or as proposed, I should say.
That's good. I mean, that's my thought and my reading as well. And certainly I think that's the intent of what we're trying to do here. Because this is an active current problem for consumers and homeowners in the state. Any questions for Lorraine? No, seeing none. Thank you for joining us today, Lorraine.
Thank you for having me.
Okay, next on our list, number 10, Bill Marone, who's in the room with us today. Greetings, Bill. Thanks for joining us.
Afternoon. Good afternoon. As you, Representative Delnecki, Representative Doucette, Senator Berthel, I'm Attorney Bill Marone. I represent the Connecticut Creditor Bar Association. I first am here with a mea culpa. I was late to sign up for the event, so I didn't show up on the published speaker list. So I apologize for that. I was reprimanded and chided. So I thank the committee for its accommodation to let me speak today.
Now you did make the list, but
Oh,
it did come in I think a second after the stated
Just in the nick of
deadline,
time.
but you were in the system. I don't know exactly how the technology works, but we did get you.
Public
And
service now to
appreciate.
sign up early. But I'm here to speak on the bill that Attorney Martinez Bellamy and Attorney Gentis spoke on very eloquently. The statute of limitations bill, raised bill 6878. Hearing the strong testimony and insightful questions from the committee, I almost ran out of the room, but I think it's a relatively important discussion that we should have. As an organization that represents attorneys, it's strange because generally we don't fight shortening of a statute of limitations, because effectively it's more business for attorneys. It means that you interact with the file earlier and more often. So that's a general sort of position, that shortening the statute of limitations may have an unintended consequence that wasn't particularly thought of. But I liked Representative Bissett. I really liked your question about the retroactivity piece. So as we sit here today, an attorney who would advise clients, and quite frankly, I don't have any clients that jump to the top of my mind that are in this space, which was, I wasn't particularly aware of it until I started to research it a little bit more. But it was what I thought, as you said at the beginning of it, sort of an under the radar issue. I didn't realize it to be an issue. I don't have any clients currently that are litigating any second mortgages in this position. I definitely don't have any clients that are predatory. And so what I would like to talk about is this session ends in June. This statute is proposed to be enacted July 1st, which means attorneys that are aware of this, who may have clients that fall in this situation, have to give good advice, saying between today and July 1st, you better sue these and start your foreclosures, because you're going to be out of time otherwise. So I have a very serious concern that the runway is very short for people to operationalize just and due debts that should be not sort of extinguished through this enactment. Second part is subsection 3, and I don't know if it's the intention, but the way I read it, and I'm going to give you an insult and call you Attorney Doucette in this one particular context, but every mortgage, and I reviewed 10 of them this morning just to make sure that what my personal experience was actually reality. has a provisions that says something to the extent of, if we do not enforce this provision at this time, we're not waiving our right to do it in the future. It's a very standard clause in the 10 mortgages I looked at this morning, going back 20 years. Section 3 says uncured default. That seems like a very blunt instrument that potentially is breaking into the parties in invalidating that provision of a contract. For example, if I have a credit union client who allows a missed payment and just says, okay, we'll deal with it at the end. They don't go through a written modification. They don't go through a process. That technically is an uncured default. And I want to make sure that if the statute moves out of committee, that we're dealing with something that isn't a blunt instrument that potentially becomes a sword and not a shield. So those are, the general concern I have with shortening statute of limitations means react earlier. The more specific to this bill would be a short runway may create a flood of people running to avoid losing their rights. And then obviously the technical would be sort of use of that word default. I'm not specifically, I can't think of any other statute that would use that type of.
Yeah. Yep. Okay. Well, thank you. No, those are good points, and appreciate you bringing them forward. Appreciate always, you've been to before this committee a couple of times at least, and I appreciate the constructive feedback and the discussion on those technical points. It's definitely helpful to us. So I mean, that is something to certainly consider, I think, the short runway, like you said. Because, that's something that we could certainly look at effective dates. We have sort of our default effective dates, but we could consider putting it off or adjusting that accordingly. It's certainly something we could do. And then the second point is an interesting one. I'll have to read that closer. I think the trick here was when to establish that the statute has begun to run. Again, looking at this last year, I remember that was sort of a challenge. We could pick a default. Then we have to determine how we document that default, like in order to trigger the statute, or we could say the last payment, which is frankly a little easier to determine, right? Because you can look at that and have that payment record of that payment to establish the date. But either way, I guess I feel like that in terms of a runway. Now we're talking about a different runway. The statute of limitations of 10 years is a pretty long time for a lot of things to happen, including various attempts at mediation, modification of the loan, or trying to otherwise do a workout with the borrower. And then, of course, if the underlying debt is sold to someone else or what have you, obviously that can happen. But I think is a pretty long time period for a creditor to exercise its rights to a foreclosure. So, when I'm always looking at these issues through the lens that you are, which I appreciate, I guess I look at, are there other remedies? Are there other ways to exercise those remedies? If we're, not to borrow a term, foreclosing, or we're preventing perhaps, or amending the procedure to exercise one set of remedies. Are there other remedies that are available? And I think it's clear that there are in this case, but this would address the issue of those really dormant.
And I recognize that. I would say a couple of quick things. I think if you're in a position where your second mortgage does not have an equity position, at some point, if your note is extinguished at 6 years by operation of 52-576, the regular statute of limitations for the debt obligation, you almost have to decision your security interest at that 6-year timeline, because if it's underwater and you're undersecured in that instance, you're going to have to sue on the note to protect it through a judge. Because I guess you could take make a bad business choice and take a property underwater and take the carrying costs and lose money on the loan. But as George Herman said earlier, the practical matter is you're in business and you're going to make good business choices. So I do think that you're going to probably see an increase in suits on the underlying note obligation. I agree, 10 years is a long runway, but the potential bad actors that Attorney Gentis and Attorney Martinez Bellamy spoke of, I guess they're not in my field of view, so I have a hard time seeing that. I would say a couple of quick things. I believe if they were in the debt buying industry, meaning purchasing charged off debt, they would be licensed by the Department of Banking as part of that field. So I do think that there is some regulatory oversight within the state specific to our licensing statute. The second piece I would say is, there are fact patterns where, you're working with somebody and you're gonna do a mortgage and let it sit there until they dispose of the property. And I guess the devil would be in the details at how you draft your mortgage, meaning if it's a mortgage that's drafted not to be in default until you sell the property, I guess this wouldn't impact it. But if, like I think bail bondsmen, for example, may take a mortgage to secure their bond and may have no intention to foreclose it. Well, their security interest will be extinguished by lapse of time, even though it was somewhat contemplated. And there's probably not a lot of sympathy for bail bondsmen, but that is a thing where the benefit of the bargain at the time that you're making the deal are things you have to factor in and will eventually factor into pricing, which will be, I am secured, but I'm only secured for this 10-year window. And hopefully there's equity in the property at that time. Otherwise, that I lose that. So I couldn't tell from the statute specifically whether or not we were saying that debt's extinguished or just the right to foreclose is extinguished. It was a little bit the way it would interplay would be, would you be able to get the mortgage removed as a cloud on title as opposed to just not be able to foreclose it? I couldn't quite tell.
Yeah, that's a good point. Let's play with that a little bit. I mean, I think the intent is we're talking about the foreclosure here because the specific issue we're talking about are these zombie mortgages. But yeah, let's just say that is the case. So yeah, you've got that 10-year statute, but you have the underlying note. In your experience, if that was the case, and we're just talking about the foreclosure here, that note still, the statute's going to run longer on that potentially if in fact that note was actively in repayment, or how would you look at that?
Well, I think if the note was in repayment, that this probably wouldn't apply to either the note or the foreclosure. I think the measures would be, unless what we talk about in subsection 3 somehow is used as a sword instead of a shield. But so I don't think a second in paying status would create any of this issue. You're not concerned.
So yeah, so when might that come into play? If the question of whether or not we're just talking about the foreclosure or the underlying obligation.
There are certain transactions. I mean, the bail bondsman jumped to my head because I had once serviced it. And so I was like, well, he never intended to foreclose on it. He didn't want to sue on the note because it was sort of recognized that we're going to wait till you dispose of the property.
Right.
That will be paid.
But could he, or does that have a does that have a 6-year statute?
Well, his note would have had a 6-year, and his security interest, which is sort of a separate creature,
Right.
has currently none and potentially 10. So they're to your point.
Right. That's
sort
an
of
interesting point.
Different pieces.
Yeah.
And honestly, advising a client, I would say, listen, you guys need to decide, are you going to sue on your note? Don't let that extinguish, because you only potentially have another 4 years to see if your equity position brings you security. Otherwise, your note's extinguished, foreclosure rights are extinguished. Now, do and own that. And I think it's a very real concern. People lose track of them. I will say Connecticut's probably better than some states because we use closing attorneys So hopefully there's not as many that aren't aware of what's left after a transaction, but I do.
Yeah,
recognize-
no, it's gonna be a unique case, but it's a valid point. It is. I appreciate that. Any other questions for Bill? Representative Delnicky.
Yeah, just one, and I was just reading through your testimony. So if this were to occur and we were to do this, your position is there would be a tremendous turnaround in foreclosures.
Well, I would say, and so if I walk out of here today as currently written, I would have to at least advise clients that, hey, listen, there may be a window of mortgages that you're currently holding that will no longer have foreclosure rights on July 1st. So you need to decide those between today and the end of this session, because if it passes, there is a very short window to get these things out, served, and protect your interests. So that was kind of what I was trying to drive at in that piece of testimony.
And you also refer to our foreclosure mediation programs here in the state of Connecticut being a bellwether that does a great job.
In my experience.
In your
yes,
opinion.
It offers an open dialogue between the parties overseen by a competent and sort of trusted third party that, can have these discussions. Now, I can't speak, attorney, the couple of things that I have to concede I lose. I'm not nearly as good as Attorney Gentis. I'm not nearly as good as Attorney Martinez Bellamy as an advocate. They offered testimony that made me want to run through.
Yep.
I'm also not going to win the marketing battle because zombie mortgage sounds like what your point was early on the share appreciation, right?
Right.
These things just pop up out of nowhere. They raise the hand from the grave. So I get those pieces, but I represent credit unions. I represent a number of entities that make valid, due, just, and owing debt obligations, and they secure that. And when they make that bargain, the security is a big piece of the pricing, right? I would give a friend $50, but if he lets me hold his phone, I'll give him $100.
Yeah.
So these are things that you have to kind of consider the unintended consequences. I think it's very well intentioned, and it maybe should be there. I won't necessarily say that. I would say that it gives me concern, and I want to make sure that we work through some of the issues, because it's not, like maybe you use a scalpel and say, this is designed to redress the harms of people from the Great Recession, and it just applies to loans made during the now we're getting a little bit more surgical, and I'd be happy to talk with Attorney Gentis and look at the actual facts, because I was similar to Attorney Doucette or Chairman Doucette. It was an under the radar issue until I was reading their testimony and read the bill. So that was all I'd say. It's an important discussion.
Well, I appreciate you coming forward and shining a different light on the issue as to unintended consequences.
Thank you.
Thank you. Thank you, Mr. Chair.
All right. Well, seeing no further questions, we appreciate you joining us today.
Nice to
Bill.
see everybody.
Okay. And I believe that actually brings us to the end of our list of people signed up to testify today. So appreciate everyone joining us today for this public hearing, and I will now declare it to be adjourned. Thank you.